There is a specific kind of silence that falls in a courtroom when something impossible happens. Not impossible in the sense that it defies physics. Impossible in the sense that it defies every assumption every person in that room has been operating on for the past 9 months. The kind of silence where you can hear someone in the gallery slowly exhale, where the court reporter's fingers stop moving, where the judge, a man who has presided over hundreds of trials and has trained himself over decades to show nothing, looks up from his bench and stares. That silence fell in Courtroom 6 of the Cook County Criminal Court on a Wednesday afternoon in October. And it fell because a defense attorney named Rachel Kim had just put something on the projector screen that should not have existed. It was a photograph. A single photograph taken by the crime scene unit on the night of the murder. A photograph that appeared in the official evidence log, had been reviewed in discovery, and had been seen by every attorney in that room. Everyone had looked at it. No one had looked at it the way Rachel had, because Rachel had noticed something in the bottom, left corner of that photograph. Something small, something that the crime scene photographer had not intended to capture. Something that, once you saw it, you could not explain away. And it meant that the lead detective on the case, the 20-year veteran, the decorated officer, the man who had built every brick of the prosecution's case, had been in that crime scene before the crime scene had been secured. There is one more thing you need to know before this story begins. The suspect the detective had built his case against was a 23-year-old man with no criminal record. And the person that same detective had been quietly protecting for 9 months, the person who had actually been at that crime scene, was his own son. Stay right here. Because what Rachel Kim did with that photograph is one of the most precise and courageous pieces of legal work Sweet Justice has ever covered. Subscribe to Sweet Justice right now. Every second of this one matters. The murder of 44-year-old restaurant owner James Whitfield had occurred on a Friday night in September. An ordinary Friday, a busy service night, the kind of night where a restaurant's rear alley fills with the rhythm of deliveries and staff taking breaks and the ordinary commerce of a working kitchen. Nothing about that Friday had suggested to anyone who lived or worked on that block that anything was wrong until the delivery driver arrived at 11:15 and found James at the base of the rear fire exit, in the alley behind his restaurant, on the north side of Chicago. James had been discovered by a delivery driver at approximately 11:15 who had come to drop off supplies for the following morning's service. He had been struck from behind. The cause of death was blunt force. Trauma to the back of the head. There was no weapon recovered at the scene. There were no witnesses who came forward. The alley had one working security camera, mounted on the rear wall of a building 3 doors down, but it covered only the far end of the alley and showed nothing useful from the night in question. The lead detective assigned to the case was a man named Frank Doyle. 51 years old. 22 years on the force. He had worked homicide for 14 of those years and had a clearance rate that his supervisors regularly cited in department briefings as exemplary. He was known among his colleagues as thorough, aggressive in his follow-up, and deeply certain of his instincts. When Frank Doyle decided a case pointed in a particular direction, it pointed in that direction. Within 48 hours of the murder, Frank's investigation had identified a suspect. His name was Reid, 23 years old, a cook, at a restaurant 2 blocks from James Whitfield's establishment, with no criminal record and no prior contact with law enforcement. The connection Frank had established was this. Marcus had applied for a job at James Whitfield's restaurant 3 months earlier and had been turned down. A co-worker had mentioned to Frank during canvassing that Marcus had complained about the rejection, saying he had felt the interview was unfair. It was a thin thread. But Frank pulled it. Marcus was brought in for questioning. He said he had been at home on the night of the murder. He could not immediately provide a witness to confirm. This, his roommate had been out of town. He was cooperative, visibly nervous in the way innocent people become nervous when they understand that the situation they are in is more serious than they initially believed. And he answered every question Frank asked him. Frank arrested him 6 days later, following the discovery of what the official report described as trace physical evidence linking Marcus to the alley. Specifically, a partial boot print in a patch of soft ground near the rear exit of James's restaurant. photographed and cast by the crime scene unit, which Frank's report stated was consistent with a boot found during a search of Marcus's apartment. The boot was a common style, sold at dozens of retailers across Chicago. The consistency assessment in the report was based on general size and tread pattern rather than any unique identifying feature. But it was in the report. It was in the evidence log. And it was enough, combined with the established motive of the job rejection and the absence of a verified alibi, for the state's attorney's office to charge Marcus Reid with murder in the first degree. Marcus had hired Rachel Kim. Subscribe to Sweet Justice right now if you are not already, because Rachel's first meeting with Marcus Reid contained a single detail that she could not make sense of. And that inability to make sense of it is what drove the next 7 months of the most methodical defense investigation this channel has ever described. Rachel had asked Marcus in their first meeting to describe everything, not just the night in question, but the months leading up to it, the job application, the interview, the rejection, and every interaction he had ever had with anyone connected to James Whitfield's restaurant. She did this with every client, as a matter of habit. She had learned, over 15 years of criminal defense work, that the most important detail in a case was almost never the one the police had built their theory around. It was usually something quieter, something that seemed peripheral, something the client mentioned almost in passing because they did not understand its significance. She asked Marcus to describe the job interview at James Whitfield's restaurant. Marcus had described it in detail. The date, the person who interviewed, him, the specific questions he had been asked. He said it had felt rushed, that the interviewer had seemed distracted, and that he had left feeling uncertain but not hostile. He said he had been disappointed when he did not get the job, but had not thought about it much after that. Rachel asked if he had ever returned to the restaurant after the interview. Marcus said no. Rachel asked if he had ever been in the alley behind the restaurant. Marcus said no. Rachel asked if he owned a pair of boots matching the description in the evidence report. Marcus said yes. He had bought them at a chain store almost 2 years earlier and had worn them regularly since. None of this was unusual. Rachel had heard similar accounts dozens of times. What was unusual was what Marcus said next, unprompted, at the end of the meeting as Rachel was gathering her files. He said, "There is one thing I keep thinking about that I do not know what to do with." Rachel put her files down. Marcus said, "The detective who interviewed me. Detective Doyle. He asked me a lot of questions about that Friday night, but there was one question he did not ask me. He never asked me who else I knew at James Whitfield's restaurant. He never asked me if I had any other connection to the place besides the job application." Rachel said, "Why does that stand out to you?" Marcus said, "Because I do have another connection. James Whitfield was the uncle of a guy I went to high school with, a guy named Danny Doyle. We were not close, but I knew him. And I always thought it was strange that the detective never mentioned that when he was asking me about the restaurant, because Danny Doyle's last name is the same as the detective's." Rachel looked at him for a long moment. Then she said, "Say that again." He said it again. Rachel drove home that evening and opened her laptop. She spent 3 hours on public records, social media, and the kind of basic cross-referencing that anyone with patience and a search engine can do, but that most people do not think to do. By midnight, she had confirmed what Marcus had described. Detective Frank Doyle had a son named Daniel Doyle, 26 years old, who had attended the same high school as Marcus Reid. Daniel Doyle was the nephew of James Whitfield through his mother's side. And Daniel Doyle had worked briefly as a bartender at his uncle's restaurant approximately 18 months before James's death. She had also found something else. A photograph on Daniel Doyle's social media, posted 3 months before the murder, in which he and his Uncle James were photographed together at a family event. The caption was warm. The comments were warm. The relationship, by every visible measure, had been a close one. And yet Daniel Doyle's name appeared nowhere in Frank Doyle's investigative file. Rachel spent the following 6 months building a case around an absence. The absence of Daniel Doyle's name from a homicide investigation in which he had a documented personal connection to the victim. The absence of any record of Frank Doyle, disclosing his familial relationship to a person connected to the case. The absence of any interview, any documentation, any mention of the Doyle family connection in 740 pages of investigative materials. She filed discovery, requests that were broader and more specific than anything the prosecution had expected. She requested the full communication logs for the lead detective's department-issued phone for the 2 weeks surrounding the murder. She requested the crime scene unit's complete unedited photograph archive from the night of the discovery. Not the photographs selected for the evidence file, but every photograph taken that night in the order they were taken, with full metadata. The communication logs came back with 17 calls and text messages between Frank Doyle's department phone and a number that Rachel traced, through a subpoena that took 6 weeks to process, to a prepaid phone registered, under a name that did not correspond to any person in the investigative file. The messages themselves were not recoverable. The prepaid phone had been deactivated. But the fact of the communication existed in the log. 17 contacts in 14 days. The last one at 11:43 on the night James Whitfield was found. 11:43. James had been discovered at 11:15. Frank Doyle had not been notified of the homicide until 12:07, according to the official dispatch log. Frank Doyle had received a call on an undisclosed number 24 minutes before he was officially notified that a homicide had occurred. Rachel sat with that for 2 days. Then the full photograph archive arrived. There were 411 photographs taken by the crime scene unit on the night of James Whitfield's murder. The evidence file contained 63 of them, the ones selected as relevant by the lead detective for inclusion in the official record. Rachel went through all 411. It took her an entire weekend. On Sunday evening, at photograph number 288, she stopped. It was a wide-angle establishing shot of the rear of the alley, taken early in the documentation sequence, before the forensic markers had been placed, before the area had been formally cordoned. A standard photograph, the kind taken at every scene to establish spatial context. In the official evidence file, a tighter version of this shot had been included. The wider version had not been. In the bottom left corner of the wider photograph, partially cut off by the frame, was the toe of a shoe. A man's shoe, dark leather, slightly pointed at the tip. The shoe was connected to a leg that extended just far enough into the frame to confirm that a person had been standing in that corner of the alley at the moment the photograph was taken. The photograph's metadata showed it had been taken at 12:23 in the morning. Frank Doyle had arrived at the scene, according to the official log, at 12:31. Someone had been in that alley 8 minutes before the lead detective officially arrived. Someone whose presence had not been logged, not documented, and not explained. Someone wearing dark leather shoes with a slightly pointed toe. A detail that Rachel cross-referenced with considerable patience against every photograph of every person documented at the scene that night. The crime scene technicians wore boots. The patrol officers wore standard-issue footwear. The detective had been wearing brown lace-ups, documented in his own scene photographs. No one at that scene had been wearing dark leather shoes with a pointed toe. No one on the official log. But Daniel Doyle had been wearing exactly that style of shoe in the family photograph on his social media, posted 3 months before his uncle's death, standing next to the man who was now dead. Do not move. Subscribe to Sweet Justice right now. Because what Rachel did with this photograph in that courtroom is the moment this case broke open completely and the room went completely still. Rachel had spent the final weeks before trial deciding exactly when and how to deploy what she had found. She understood that the photograph alone was suggestive but not conclusive. It showed a shoe, not a face, and any competent opposing attorney would immediately challenge the identification. What made it powerful was its combination with everything else: the communication log, the undisclosed family connection, the 17 calls to an unregistered number, the timing. Each piece was a thread. Together, they were a rope. She waited until the prosecution had finished presenting its case. She waited until Frank Doyle had testified, had sat in that witness chair and described in his direct examination by the prosecutor the careful and thorough investigation he had conducted. He had been composed on the stand. He had been credible. He had answered every question from the prosecutor with the ease of a man who had testified many times before and knew exactly how to occupy a witness stand with authority. Then Rachel had stood up for cross-examination and put the photograph on the screen. She had not said anything when it appeared. She had let it sit there for 4 full seconds. The wide-angle shot, the alley, the corner with the shoe. Then she had looked at Frank Doyle and said, "Detective Doyle, this photograph was taken at 12:23 in the morning on the night of James Whitfield's murder. Your official arrival time at the scene is logged at 12:31. Can you explain whose shoe that is in the bottom left corner of this frame?" Frank Doyle looked at the photograph. He said, "I cannot identify a partial shoe from a crime scene photograph." Rachel said, "That is fair, Detective. Let me help you." She clicked to the next image, a side-by-side comparison of the shoe in the photograph and Daniel Doyle's social media photograph. She said, "The shoe in the crime scene photograph and the shoe worn by your son in this photograph taken 3 months before the murder appear consistent in style, color, and toe shape. Do you dispute that?" Frank said, "Those are 2 different photographs taken in different conditions. Any comparison would be speculative." Rachel said, "Then let me ask you a different question. Your son, Daniel Doyle, is the nephew of the victim, James Whitfield. Is that correct?" A pause. 1 second. 2. Frank said, "That is correct." Rachel said, "And you did not disclose that relationship when you were assigned to lead this investigation?" Frank said, "I did not believe it was relevant. My son had no involvement in this case." Rachel said, "Detective Doyle, in the 14 days following the murder, your department-issued phone made or received 17 contacts with a prepaid telephone number that does not correspond to any person documented in your investigative file. Can you tell this jury who you were communicating with?" Frank said, "I do not recall every communication I make in the course of an investigation." Rachel said, "The last of those 17 contacts occurred at 11:43 on the night of the murder. You were officially notified of the homicide at 12:07. That means you were in communication with an undisclosed number 24 minutes before you were notified that a crime had occurred. Can you explain that?" The silence that followed that question was the silence I described at the beginning of this story. Frank Doyle said, "I would like to consult with an attorney before answering any further questions." Judge Henry Coleman looked at Frank Doyle. He looked at the prosecutor. He looked at Rachel Kim. He said in a voice that was completely steady and completely without theatrics, "Detective Doyle, you are on the witness stand in a criminal proceeding. I am going to ask you one more time to answer the question, and I am going to advise you that your response or your refusal to respond will be a matter of record for this jury." Frank Doyle said nothing. Judge Coleman looked at the jury. He said, "The jury will note the witness's response. Ms. Kim, you may continue." Rachel said, "Nothing further, Your Honor." She said it the way she said everything, without emphasis, without visible satisfaction, without any of the theatrical release that the moment might have invited. She had asked the questions she had spent 7 months earning the right to ask. The answers, the silence, the refusal, the single sentence, about consulting an attorney, had done exactly what the evidence had always suggested they would do. She did not need to add anything to that. She sat down. The prosecutor requested an emergency recess. It was granted. In the 45 minutes that followed, the case against Marcus Reid was effectively over, not because any single piece of Rachel's evidence was conclusive, but because the combination of all of it, delivered in a cross-examination that took less than 12 minutes, had made the prosecution's case impossible to present with a straight face to any jury that had been paying attention. When court reconvened, the gallery had refilled completely. Word had moved through the building in the way it always does in a courthouse when something significant is happening in one of the rooms, quietly, specifically, and with complete accuracy. Attorneys from other proceedings had slipped into the back rows. A journalist who had been covering the trial intermittently was now in the front row with her notebook open. The prosecutor stood and said, in a tone that carried the specific weight of a decision made during an extremely uncomfortable 45 minutes, "Your Honor, The state moves to dismiss the charges against Marcus Reid pending further investigation. Judge Coleman looked at Marcus Reid. Marcus Reid had been sitting at the defense table for 9 months, through arraignment and motions and depositions and the 11 days of trial that had preceded this moment, with the particular stillness of someone who has exhausted every resource except patience. He looked at the judge. Judge Coleman said, "Motion granted. Mr. Reid, you are free to go." Marcus Reid sat completely still for a moment. Then he put his face in his hands. The investigation that followed the dismissal moved quickly in the way that investigations move when the circumstances are sufficiently embarrassing to the institution conducting them. The Cook County Independent Inspector General's office opened a formal review of Frank Doyle's conduct within 10 days of the dismissal. The prepaid phone number was eventually traced, through a process that took 3 months and 2 court orders, to a device that had been purchased at a convenience store near Daniel Doyle's apartment. Daniel Doyle was interviewed formally for the first time. He retained an attorney before the second interview. Frank Doyle was placed on administrative leave pending the outcome of the review. He was subsequently charged with obstruction of justice, evidence tampering, and misconduct in office. The charges alleged that he had been contacted by his son on the night of the murder, had arrived at the scene before his official notification time, had taken steps to ensure that his son's connection to the crime scene was not documented, and had constructed a case against Marcus Reid using evidence, specifically the boot print assessment, that he knew to be insufficient. He pleaded not guilty. His trial was scheduled for the following year. Daniel Doyle was charged separately with second-degree murder in the death of his uncle, James Whitfield. The specific circumstances of what had occurred in that alley on the night of the murder, why it had happened, what the relationship between uncle and nephew had deteriorated into, and what Daniel had expected his father to do about it, were the subject of an investigation that would take more than a year to fully develop. Marcus Reid gave a statement outside the courthouse the morning after the dismissal. He was 23 years old. He had spent 9 months with a first-degree murder charge over his life. He said 3 sentences. He said, "I always knew the truth would come out. I did not always believe it would come out in time. I am grateful that it did." He thanked Rachel Kim by name, saying that she had given him something beyond legal representation, the experience of watching truth matter at the exact moment it needed to. Rachel was standing 10 feet away and did not react. Visibly, she had learned over years of this work that the moment a case ends is rarely the moment it feels finished. There was still a trial ahead, still the full truth to be established. Still a family, James Whitfield's family, who needed answers that a dismissal did not yet provide. She gathered her files. She walked back into the building. She had work to do. That is what sweet justice looks like when it is still in progress. Not a clean ending, not a single moment where everything resolves. A photograph in a corner of a frame, a question asked in 12 minutes that took 7 months to earn the right to ask, and a 23-year-old man who walked out of a courthouse because one attorney looked at 411 photographs on a Sunday evening and did not stop until she reached number 288. Subscribe to Sweet Justice for new courtroom stories every day. Share this with someone who needs to believe that the truth leaves traces. Hit that bell and stay with us. We will see you very soon.